Queen's Counsel Khawar Qureshi told the five-judge bench presiding over a graft case involving the DCJ Philomena Mwilu that there is no law preventing a sitting judge from being tried in a criminal court.
Qureshi also explained to the court how the DCJ allegedly irregularly obtained a loan from a commercial bank without proper documentation. NTV's Seth Olale attended the hearing at the Milimani Law Court and filed this report.
Day 2 of the hearing of the graft case against Deputy Chief Justice had the prosecution led by Queen's Counsel Khawar Qureshi submit evidence before the five-judge bench led by Justice Helen Omondi at the High Court.
Petitioner was engaged in buying and selling property.
The Queen's Counsel was in company of Deputy Director of Public Prosecution Dorcas Oduor, State Prosecutor Alexander Muteti, together with Attorney General's Counsel Emmanuel Biita. Qureshi started by clarifying that a sitting judge can't be tried in a criminal court of law before appearing in the Judicial Service Commission.
The petitioner appears to be more comfortable with abandoning the presumption of innocence, with appearing before the Judicial Services Commission in private, without public presence, where she seems to believe that allegations of dishonesty could be considered. And what would be the standard of proof?
The Queen's Counsel further explained how the Deputy Chief Justice allegedly irregularly obtained an unsecured, undocumented and zero interest 12 million shillings loan from Imperial Bank Limited and only paid when the bank had gone under receivership 2 years later.
That there is a substantial amount of indebtedness, some 49 million shillings, which is now unsecured. Indeed, it would appear that the proposed replacement security was, in fact, sold and could never have been provided.
Qureshi told the court that the irregular bank transaction was aided by suspicious direct dealings the DCJ had with the then managing director of Imperial Bank Limited without verification from any other bank official, and that the prosecution has evidence of the Deputy Chief Justice personally attending the late MD's funeral.
And what she's asking for is a loan facility to purchase property valued at 120 million shillings. She's seeking a facility of 70 million. And she told us that she's negotiating at arm's length with the bank in the same way as any other private customer would. But let's just see who this was written to. Top left, the group managing director, no less. Now, I suspect that the Imperial Bank is no different from any other bank. And I doubt very much that there are many customers, save for those who are extremely privileged, I wasn't going to say influential and well-connected.
The Queen's Counsel further defended DCI's involvement in the transaction, stating that the Kenya Revenue Authority raised the alarm over suspicious transactions, leading to the DCI and DPP swinging into action. Qureshi suggested to the court that such suspect transactions contributed to the collapse of Imperial Bank Limited with 34 billion shillings due to gross mismanagement that necessitated massive fraud. All the parties represented in the graft case implicating Deputy Chief Justice Philomena Mwilu will issue the final submissions on Thursday when the hearing continues. Seth Olale, NTV, Milimani Law Courts, Nairobi.